So this is kind of a question to the world, I guess, or maybe I I think the only people that can answer my question is like in the Crown's office. But I guess I'm more interested in transparency. Um, I was charged in 2020, July 2020. I was charged with a count of extortion, several counts. The make and distribute child sex abuse material that came later, still in 2020 though. So that was in relation to, oh, sorry, also harassing communications. That was in relation to um, my involvement in a project called Creeper Hunter TV. They basically prosecuting me for trying to catch child predators online. And and in this scenario, they're basically charging what effectively is the child. And they withdrew charges against predators. In the course of this, in the course of this leading up to trial, and this went to trial for 4 weeks. This is the scheduled first date of trial. And I believe that we were in court when my lawyer sent this to me. This is my lawyer sending me the undertaking to not prosecute. The Crown attorney was going to withdraw most of the charges, the extortion, the create and distribute child sex abuse material, and I was going to be looking at pleading guilty to only harassing, a single charge of harassing phone calls. And for this, they were going to give me $20,000 worth of computers back. They were going to give me the non prosecution agreement. They were going to have me be on house arrest for 12 months. And what else? They were going to wipe the computers. So the police were going to basically do like a wipe, so I couldn't have access to these materials afterwards. Like videos of going to get predators and the text messages and stuff. And so ultimately I turned this down. And I don't know why it is that they offered me the non-prosecution agreement. I mean, I think that they were kind of worried about the possible outcome. This is going to be a jury trial. And like, if you're talking about prosecuting somebody that's trying to prevent predation online, like, how does that look in front of the jury? And it was kind of like unforeseen as to how this trial might roll out. But in my position, I'm thinking, oh, the Crown really wants to resolve this. Like, they are concerned about the outcome of trial. So I was like open to discussing this. So we went back a few times, and then ultimately I turned it down. We never went to like a mediation or anything. I mean, think about, 3 years of preparation for this. 2 weeks before trial were just nonstop preparation around the clock. 2,000 pages of documents, hundreds of videos and pieces of media that the Crown is wanting to rely on for this expected 4 week trial. And the Crown's now wanting to prevent the trial from going ahead. Why? Why were they so gung-ho about getting this to not go ahead? One of the huge sticking points from my perspective, and we never really explored it, was this idea of a definition of jurisdictions. What does jurisdictions actually mean in this context? Was it just I was going to be immune from being prosecuted for creeper hunter stuff in London, Ontario, and Middlesex, or was it all of Ontario? I think eventually, orally, the Crown said that it would be all of Ontario. He had the power, and he was going to talk to the Attorney General about about all of Ontario sort of being off limits. There were catches that were done outside of Ontario, but I think probably about 50 or so percent of the catches happened in Ontario. So my fear was is that they could keep doing this over and over again. And this was one of the sticking points as well for me. Like I wanted them to define what new offenses meant. Did that mean like stuff that was already in their possession? Because that doesn't say that to me. Any new offenses involving the targets or catches on Creeper Hunter. So like this was not this was a sticking point for me, the non-prosecution agreement. But if it was I went ahead with this, I think that the Crown could have easily slipped out of this agreement. And they could have still kept prosecuting me over and over and over again. I mean, indefinitely. There was so many predators in those files that I'm sure that they could have, kept finding offenses to try and prosecute me for. And this is why I knew that I needed to be getting a not guilty verdict so that I could have my stuff returned to me and that I could move on with my life. Like one of the, some of these conditions, as you can see, was, don't take part in Creeper Hunter TV again. Get rid of Creeper Hunter is what they were wanting. And what I had no problem with that. I had moved on at this point when I was charged in July of 2020. I had no problem with that. Like this was the main sticking point right here. And I think this. But like as far as moving on from Creeper Hunter, I had already done that. I had announced it. Like Creeper Hunter was going to be no more. The videos would have still remained in the, webverse, but I was not going to be producing anymore. I was not going to be participating. Some of the other people in the project were going to still do stuff, but it wasn't going to be like for Creeper Hunter. It was going to be for their own projects. And I estimated that this trial cost the government about I guess anywhere from $350,000 to $600,000 for the 4-week trial, 4-week jury trial. And looking back at it, I guess I also had an issue with the 12 months house arrest because 12 months house arrest compared to what I have received and what I've gone through now is just a walk in the park. This harassing phone calls, though, at the time, harassing phone calls, 12 months house arrest was like very strict and very stringent. And I was like, this is very disproportionate. Like, if you were to go through a trial and fight and be found guilty of harassing phone calls, you might get 20 days in jail. Maybe 1 year probation, maybe, depending on the circumstances. But like 12 months house arrest for harassing phone calls, no. They were basically asking for 12 months, bundling together the thought of the other charges. So that's another reason why I turned this down. And I'm just kind of curious as to why it is that the Crown didn't want to really resolve this. Why didn't they want to save the victims, I say victim very loosely, very in quotes. There's really no victim here. This this person that's blurred out here, and this is all redacted. I redacted this. Obviously, there's stuff that can't be talked about publicly, but like this person who was deceased, who the extortion charge was based on, the um who some of the text messages were in relation to. Um, this person clearly committed an offense. Clearly, he was investigated. He was reported to the police. I cooperated with the police to report this person. And this person was found dead several days after a video was posted. He went missing and there was a wellness check. He was found at a motel, like, I don't know, I guess he lived in London or wherever, but then he was found at like a small little motel by the OPP, and they did a wellness check and they basically found him, and he went missing. And then that officer testified at some point, I think in the preliminary hearing, and she basically said she wasn't concerned about his welfare. And he didn't complain about anything. He didn't complain that there was a video out there about him. He didn't complain about anything. And then like a couple days after that, he was found dead on his knees with string around his neck in the forest in London, Ontario. And that is the reason that they said they started investigating me. But it's clear to me, like, if you're found on your knees, like, if the proposed cause of death is asphyxiation, which it was, the problem with that is, how can one unalive themselves if they are having the ability to stand up? Like, I don't get that. I think there's a huge problem that my brain has connecting those two. Like, I could see, and you see in TV and film and stuff, how like people stand on something and they don't have the ability to stand up. The body, I presume, I don't know for sure, the body will, like, you know, cause yourself to like wake up, or if you're even sleeping and you're trying to, and you're asphyxiating, like, there's a reaction that I think will happen to wake yourself up and to cause yourself to, like, I don't think that's something that a person even has control over. Maybe I'm wrong, I don't know, but like there was a bunch of suspicious things that happened in this person's life, and it's clear to me that somebody went to his house. One of his daughters testified saying that somebody went to their house and suddenly knocking on their door. The police officer, when she investigated, this crooked police officer, Officer Johnson, she basically tried to make a suggestion that it was my car to the child, to the, I don't know, I think she was like 16 or something at the time, to the daughter of this person who's interviewed. They tried to suggest that it was my car, or the car that I would have been driving, that was in the driveway, and they couldn't have been further from it. Um, it was like, it seemed to be a few people were looking for him. And who knows who found him? The police found him. Other people could have found him. And forced him to do what he ultimately did, what it appears that he did with string around his neck. But again, final resting place on your knees, sitting on your feet with your bum back on your feet. Like, how does that happen? But in any case, this is not a video about that. This is a video about why it is that they didn't really want this to resolve. Why this reckless Crown attorney, who was already in a position of conflict going into the trial, why did he not want to actually resolve this? He wanted to shame me in the media. He wanted to make these asinine suggestions, and he wanted to pollute the minds of the jury. And he did. He did it successfully. That's the only reason why. That's the only reason why I was found guilty. Because this piece of garbage polluted the minds of these jury members for no good reason. This same Crown attorney went to another lawyer in the London area and told this lawyer that their child, that this woman's child, this lawyer, she's a defense attorney in London, that her child was on Creeper Hunter. Instead of bringing charges against the child of this lawyer, this Crown attorney just gave her a heads up. Hey, your kid's up on Creeper Hunter. He was on Grinder. He was on Grinder, and guess what? I ain't calling the police. I ain't calling the police. I'm not doing that. No, 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 no. And later, the same Crown attorney, a month after this trial finishes, after I'm found guilty, brings a charge against me. And then in that charge of intimidation of judicial participant, in that charge, he lied under oath. I don't know why. I'm going to get the transcript and I'm going to put it out there. But he lied under oath. I was found not guilty of the intimidation charge. So, like, what is it possibly? Like, they wanted me to suffer. Like, all of this since the 3 years that this has taken place, that I have more than that. It's been 6 years. Like, if we're talking about, like, being charged for an offense in July of 2020, that's really when the suffering has started. And now this is at the Court of Appeal. I have a feeling that this may go up to the Supreme Court. I mean, this is a very serious national issue here of, like, I'm not going to speak about the appeal. So the appeal will take its own course. Why? Why does the London Crown's office offer a non-prosecution agreement? Why don't they want it to move ahead? They could have clarified what new offenses meant. They could have bent a little bit on the unreasonable position of 12 months house arrest. 12 months house arrest for harassing phone calls. One single charge of harassing phone calls. They could have. It would have been arguable about whether or not 12 months should have been. But the joint position Like, I think they were offering this as a joint position, and 12 months. Yeah, I mean, looking back at it now, I mean, I could have done that on my head. 12 months, I have done, I think, 8 or 9 months on house arrest, and that kind of flew by. I got a lot of stuff done while I was on house arrest. And that was without a GPS monitor too. So like I've been very fortunate as far as this has been concerned, this serious set of events. But by no means do I think this is over or ending anytime soon. Like, hopefully the appeal is finished within the next couple months. That's what my lawyer tells me. But who knows? I want to put all this behind me. Like, I can't imagine. Oh, for sure, this goes, if a new trial gets ordered, this goes in front of a judge alone. Like, I cannot trust the crown anymore with these set of circumstances, with this fact pattern. Like, to pollute the minds of jury members like they did. Like, I am still trying to recover from this. The suggestion that was made, one of the many suggestions that was made that was just like completely baseless, was that I was somehow sexually attracted to turning on pedophiles. Somehow. And it was completely baseless. And it was something that they based most of their case around. Like, I think I heard him say something around the effect of he didn't really have a theory for he didn't really have a theory for the create and distribute child sex abuse material, but eventually landed on that. Oh my God. Anyways, what do you think? This needs to be out there. If you're dealing with similar things, it's good to kind of know this and be aware of it and know these dirty little tricks that the government will try and do to play the card game that is a criminal trial in Ontario, Canada.